In the business world, circumstances can change unexpectedly, making it necessary to revisit agreements. The revocation of contracts is a legal mechanism that allows parties to annul agreements under specific conditions, effectively rendering them void. This process ensures fairness and accountability in business transactions and is governed by legal frameworks and contractual terms. Contracts can be revoked either through mutual agreement or unilaterally when certain grounds, such as breach, fraud, or illegality, are met. Let's start with the grounds for revocation. Mutual consent. The simplest way to revoke a contract is when both parties agree to terminate it. This is usually formalized through a termination agreement that outlines the terms of dissolution. Breach of contract. If one party fails to meet their obligations, the non-breaching party has the right to revoke the contract after providing proper notice. Misrepresentation or fraud. Contracts based on false information or deceit lack genuine consent and are invalid. Illegality. Agreements that involve illegal activities or are rendered unlawful due to changes in law are automatically voidable. Incapacity or duress. Contracts signed under coercion or by individuals lacking legal capacity, such as minors, are also subject to revocation. Revocation is not a simple decision. It involves a well-defined process to ensure legal compliance. The key steps include reviewing the contract terms. Carefully examine the agreement for termination provisions or penalties. Seeking legal advice. Consult a lawyer to validate the grounds for revocation and plan the next steps. Notification. Provide formal notice to the other party, clearly outlining the reasons for revocation. Negotiation and mediation. Before taking formal action, attempt amicable resolutions to avoid potential disputes. Documentation. Finalize the revocation through formal agreements or, if necessary, court orders to ensure clarity and compliance. Revocation carries significant implications for all parties involved. Legal liability. Unjustified revocation can lead to breach claims, penalties, or damages. Financial losses. These may include forfeited payments, legal fees, or compensation awarded to the aggrieved party. Reputational risks. A contentious revocation can harm trust and future business opportunities. Operational disruptions. Breaking essential contracts can disrupt supply chains and affect business continuity. Instead of outright revocation, consider legal remedies and alternatives such as rescission. This nullifies the contract and restores parties to their pre-agreement state. Reformation modifies the contract to reflect the original intentions of both parties. Damages compensates the non-breaching party for losses incurred due to a breach. Preventive measures can help minimize the need for revocation. Ensure contracts are clearly drafted, conduct thorough due diligence, and include contingency clauses for unforeseen events. These steps can reduce the risk of disputes and simplify the resolution process. Revocation processes can vary by contract type. Employment contracts, often governed by labor laws and termination clauses. Real estate contracts, typically involve high financial and legal stakes. Service agreements include performance benchmarks and predefined remedies for noncompliance. In conclusion, contract revocation is a powerful legal tool, but it must be approached with caution. By understanding the grounds, following the correct process, and considering alternatives like negotiation or mediation, businesses can navigate these complex situations effectively. With clear drafting, diligent preparation, and expert legal advice, you can manage risks and maintain the integrity of your contractual relationships.